Today we're going to look at two, I can't say cases because one is a case and the other one is not yet a case. But we're going to look at two trade-related climate measures. We're going to look at the American Inflation Reduction Act, and we're going to look at the European CBAM. Let's start with the United States Inflation Reduction Act. Now, with regard to that trade-related climate measure, there is already a challenge. There is a challenge by China. China challenged this measure. China complainant, the United States respondent, and there are no less than 25 third parties. That's not an absolute record, but that comes very close to an absolute record. Now, unless I read through the list too quickly, I didn't find India's name. And I wonder why. Yeah, so you might want to check for yourself whether India is indeed or is not. Perhaps I read through the so long list, but I didn't find India. So correct me if I'm wrong, and if I'm not wrong, ask yourself, why is India not a third party in this case? The timeline, well, we have not much of a timeline yet. We had a request for consultations in March of last year, and the panel was established in September. And in the meantime, the panel has also been composed. So there is a panel composed by the Director General. Now, the fact that the panel is established is a very important element. Why is that? Well, before I start talking about the main features of let's first talk about the main features. The Inflation Reduction Act is, as I said before, it's really a huge misnomer, because you would expect it to deal all with inflation and inflation reduction, which at the time that it was adopted was indeed a major political issue. 2024, early 2024. This was 2023 was a major issue, inflation. But this is an act that doesn't really deal with inflation reduction. It deals with, and it is the most ambitious climate action in US history. And that's a quote. And that's a quote from the USTR website. So that's what they say themselves about the act. It provides for $317 billion in government incentives. I almost said subsidies, but there's more than subsidies. These incentives come in various forms. They come in the form of grants, they come in the form of loans, they come in the form of tax credits. Government incentives to support green energy projects. And just to give you an example of a few of these projects, or the form that they can take, you have investment in and deployment of clean energy technology and green vehicles. It's particularly the latter that we will focus our discussion today. And you also have the promotion of green electricity generation. So I'm making this point because the IRA is broader than just focusing on electrical vehicles. Our discussion today will be focusing on electrical vehicles, but don't walk out of this classroom with the idea that the IRA is only about electrical vehicles. It's not. Now, before I explain, yes. Okay, yes. I'll take that up in what I'm going to say now. Before I go and talk about the specific claims of inconsistency, of WTO inconsistency, my microphone is doing funny things.
There's a speaker right above.
Should I stay away from that? Not yesterday, but apparently. Okay. Before I start talking about the specific claims of inconsistency that China has brought now, I need to say something else. Mr. Trump has on more than one occasion expressed serious doubt about the Inflation Reduction Act, serious doubt about his huge effort to address climate change. That should not come as a surprise because Mr. Trump is a climate change denier. He has suggested that we may repeal the IRA. Now, I honestly doubt whether he will, because there is significant political support in Congress for the IRA. And why is that? Well, because it's a subsidy program and it subsidizes industries, manufacturers in some very important constituencies for Mr. Trump. So these constituencies, the senators and these members of the lower house are not going to be very happy when Mr. Trump is going to withdraw the IRA. Why did the IRA get adopted in a Congress that had many climate doubters in it? Just because it was this combination of trying to do something about the climate crisis, but at the same time supporting the domestic industry. So I have my doubts whether Mr. Trump will really withdraw the IRA. But even if he does, since the measure was in existence at the time that the panel was established, the panel will keep jurisdiction over the case. Now, your question, the difference between the panel being established and the panel being composed. When a panel is composed, what happens is that the DSB, when the panel is established, what happens is that the DSB decides to create the panel. But the panel is empty. There's nobody on the panel when it is established by the DSB. After the panel is established, the parties first will try to agree on who the panelists will be. And in about half of the cases, the parties are able to agree on who the panelists will be. I mean, I'm currently in 2 panels, and in both cases, the parties agreed on the composition of the panel. Now, it also happens, that's the other half of the cases, that the parties cannot agree on who the panelists will be. It's actually very, very controversial, the composition of the panel. And then it's the Director General that will be responsible for composing the panel. That's the difference between the two. And the composition, of course, is later than the establishment. And sometimes significantly later. It can be very quickly, but parties also sometimes take a long time before they decide, or one of them decides to go to the DG, because they try to agree on because if the DG puts together the panel, they have no control whatsoever. The DG will, of course, invite them, and they will talk about who they would want as panelists, and those that have been blacklisted before in the process, the DG will not take, but they lose control. Anyway, but the important point here to make is that even if President Trump would decide to repeal the IRA, a panel, whether they will or not is another thing, but a panel has still jurisdiction to rule on the case. Now, why is that? This is something that panels did, or a panel did in the early days. And then, of course, the respondent says, no, on appeal, they said the panel should not have ruled on this case because the measure was withdrawn. The panel body said, no, the panel keeps jurisdiction for the following reason. If you would allow the panel to lose jurisdiction the moment that the respondent withdraws the measure, and so the measure no longer exists, then what you could have is that there's a measure, complainant starts a case, the respondent panel is established, the respondent withdraws the measure, and the panel loses jurisdiction. And then a few weeks later, they reintroduce the measure. Again, a panel is established, and they withdraw the measure again. And to avoid that sort of, even if you withdraw the measure, but the measure was in existence at the moment of, the panel will rule on the consistency of the measure. Now, of course, the remedy then will be not to withdraw the measure because the measure is no longer there, but there will be a ruling of the inconsistency of the measure that as it had existed. Okay. Now, what are the specific measures challenged by China in this case? There are two measures that are challenged, and we'll only talk about one. First measure that is challenged is the clean vehicle tax credit. The other measure is the renewable energy tax credits. That actually, there are a number of them, and we will not be talking about those. Looking at the clean vehicle tax credit, what are the stated objectives? What does the United States in the IRA itself state as being the objectives of this measure? Well, first of all, that's what we would expect to see. To promote the use of electrical vehicles to reduce greenhouse gas emissions. And actually, they're very ambitious there, because the IRA has as a target that by 2030, 50% of the vehicles will be electrical vehicles. 50%. Now, and last year, 2024, that was still only 6%. And the IRA has already been criticized as being completely unrealistic in that sense. Also, because of the restrictions that the IRA is going to impose, which we will see in a minute. So, let me say it's still this. If the United States would remain open for Chinese electrical vehicles, then the 50% might possibly be a realistic target. But since they're basically going to almost exclude or make very unattractive Chinese electrical vehicles, because in addition to what we're talking about here, there is already 100% customs duty imposed currently by that administration 100% customs duty on Chinese electrical vehicles. With 100% customs duties, you actually don't have any imports anymore. But so this 50% target without Chinese imports is not going to be met. Second objective, is to spur domestic manufacturing of electrical vehicles. And so purely, and has little to do directly with fighting climate change. This is more like encouraging domestic production, encouraging helping out a domestic producer. And then finally, strengthening supply chain with like-minded partners. There's also a geopolitical element in there. Like-minded partners. I wonder whether Mr. Trump will consider Europe a like-minded partner. Now, looking more specifically at the features of the clean vehicle tax credit. If you buy American and you buy an electrical vehicle, you can get a tax credit of $7,500 US. That's a serious amount. But there's some conditions that need to be fulfilled. First of all, this has to be an electrical vehicle that is of which the final assembly has taken place in North America. And North America being Mexico, United States, and Canada. And this is a reflection of the USMCA, the successor of NAFTA. It's a reflection of the existence of free trade agreements between these three countries. So final assembly in North America. And not the only thing that is required, there has to be a percentage of the value of critical minerals that are used in the batteries. And the most important thing of an electric car is the battery. A percentage of the value of the critical minerals in the batteries is to be extracted processed in the United States or a free trade agreement partner. And there are currently 22 countries and entities that qualify in that way as a free trade agreement partner. Or the critical minerals have to be recycled in North America. If you meet that condition, you get half of the 7,500. To get us 7,500 has been split in two. And if you meet that, the condition under the third bullet point, then you get the first 3,750. To get the other part, to get the other 3,750, your electrical vehicle has, of course, to be finally assembled in North America. But there's also a requirement that a percentage, and I forgot to say that the percentage for the value of critical minerals in 2027 has to be 80%. Yeah. I'm going back to where I was. You get the second half of the tax credit if a percentage of the value of the battery components is produced or assembled in North America. And in 2027, that will have to be 100%. So 100% of the battery components has to be produced in North America. It doesn't stop there. To get any of this, to get any tax credit, there cannot be any battery component that is manufactured in a foreign entity of concern. Now, and let you guess what a foreign entity of concern is for the United States. China. Now, the IRA doesn't say that. It's being delegated elsewhere to decide what is a foreign entity of concern, but this is clearly China. Moreover, none of the critical minerals that is extracted, processed, and recycled can be extracted, recycled, processed in, again, a foreign entity of concern. This is a huge problem, because at the moment, for a number of these critical minerals, virtually everything is extracted and processed in China. They have a quasi-monopoly on a number of the critical minerals that go into batteries. The United States is now making huge investments to try to encourage the mining of these critical minerals in the United States itself, or in North America, or elsewhere, because there will still be some possibility here to get it elsewhere. What are China's main claims of inconsistency? Well, first they argue that it's inconsistent with Article 1.1, the most favored nation treatment obligation. And secondly, with Article 3.4, the national treatment obligation, and the TRIMS agreement. But as you'll remember from yesterday, if you show inconsistency with Article 3.4, the inconsistency with the TRIMS agreement follows automatically. Very important, China, and that's where they will most likely be very successful. They also claim inconsistency with the subsidies agreement, and in particular Article 3.1b. We've already discussed that yesterday too. That is the prohibition of import substitution subsidies. Let's talk about the consistency of tax credit involved here with the subsidies agreement first. And as I said, this is almost a certain win. And for the following reasons. First of all, you have to see whether the subsidy is a subsidy that is covered by the subsidies agreement. What is the test there? Well, you have to have a financial contribution. Do we have a financial contribution here? Yes, we do have a financial contribution. There's a government revenue, otherwise due, foregone. Secondly, there has to be benefit conferred. Benefit conferred to the buyers of electrical vehicles. Now, here there is something that I need to say, because it's sometimes confusing. A subsidy within the meaning of the subsidies agreement is not limited to subsidies that are given to producers. If you read the definition of which subsidies are covered, you do not find any reference to the producer, because this is definitely not a subsidy to the producer. This is a subsidy to consumers. But obviously the producers are going to benefit from it indirectly. But you don't even have to build up this reasoning of direct or indirect. No, the definition of which subsidies fall under the subsidies agreement does not refer to producers. So is a benefit conferred to the consumers? Yes. To the buyers of these electrical vehicles, obviously, there's a benefit of 7,500 US dollars convert. In order for a subsidy to be subject to the subsidy disciplines of the WTO, a subsidy needs to be specific. Generally available subsidies that go to everybody in the economy, are not what we call specific subsidies, and they're not subject to the subsidy. If there would be a tax reduction or a tax rebate of 7,500 across the whole economy, it would not be. But since we're talking about, since China is going to argue that this is an import substitution subsidy, the specificity is deemed. There's a presumption of specificity. So we don't, if we are, we'll do that in a moment, if we are successful, if China is successful in showing that it's an import substitution subsidy, we don't really have to go into a specificity analysis. We can deem it to be specific. That is true for also export subsidies. The prohibited subsidies are presumed or deemed to be specific. Now we have to see whether indeed this is an import substitution subsidy as China claims. What is an import substitution subsidy? It's a subsidy that is contingent upon the use of domestic over imported products. Well, I mean, you don't have to be a genius to know that this is not the case here. Could not be more clear. If I were to give an example to students, I would give this as an example of an import substitution subsidy. And there's no justification available. So if you find that this is a prohibited subsidy, and there's no justification available, there's no Article 20 equivalent in the subsidies agreement, and the category of non-actionable subsidies has disappeared. It's no longer there. And as I said yesterday, even if it were still there, it would not be of much help, because these non-actionable subsidies, non-actionable environmental subsidies, were pretty narrowly defined. Right? Okay. Now, let's look at this measure from the GATT and TRIM's perspective. Then first, the national treatment obligation, Article 3.4. Test under Article 3.4, yes. Article 2, paragraph 5. Check that, or is it paragraph 4? Which explicitly states that prohibited subsidies are deemed to be, prohibited subsidies are deemed to be specific. Yeah, but is it 4 or 5?
It's 3.
It's
3. 4.3.
Oh, okay. Yeah. No, there's an explicit provision. Yeah. All right. So national treatment obligation. What's the test? First element of a test is the measure affecting sales. Definitely. Yeah. Second question, are the products involved? Are they like the ones that get the tax credit and the ones that do not get the tax credit? Are they like products? I was reflecting on this this morning, because I mean none of this is yet played out. But I was reflecting on this morning, and one way of approaching it is, of course, to apply the likeness test, and then you determine the extent and the nature of the competitive relationship between the products that that meet all these conditions and the products, the electrical vehicles that do not, and product characteristics Well, basically the same. End use definitely the same. Consumer tastes and preferences. Well, you may find some nationalistic Americans that would prefer the cars that have everything North American in them. But there's the threat classification, definitely the same. That's one approach. The other approach is that I think you could say here that the distinction between the cars that is made really refers to origin, be it the origin of inputs in these cars. And then there is a presumption of likeness. There's a presumption of likeness if the distinction that is made between the products is merely based on the origin of the cars. It's pushing it a bit, and I don't know. I mean, if I were their lawyer, I would argue both. Yeah? But I would definitely try the presumption of likeness. So, whatever road you take, I think the products are like. Yeah? Which brings us to the last question, namely under Article 3.4, and therefore also 1. Does the tax credit afford treatment less favorable to the like electrical vehicles that are being that do not meet these requirements? Import, but do not meet these requirements. Yes, obviously. Yeah. So there's a violation of Article 3.4. And it would be interesting to see how the United States is even going to defend itself on this. Now, with regard to the national treatment obligation, with regard to the most favored nation treatment obligation under Article 1.1 of the GATT, again, go through the test. Is tax credit a measure that is covered by Article 1.1? Answer, yes. Yeah? It's clearly a measure that is covered. It's a measure that is covered by Article 3.4, and because it is within the scope of application of Article 3.4, it is also covered by Article 1.1. Is the tax credit an advantage? Yes, it's definitely an advantage. Yeah. Again, the question of likeness, and there we have already come to the conclusion, depending on which test you do, and whether you go through the presumption of likeness or whether you go through the application of the likeness test, they're like products. And is the advantage according immediately and unconditionally to like products? No, definitely not. Yeah. So there's also a violation of Article 1.1. The violations, you never know what the United States is going to try, but I think the violations are not going to be avoidable. I mean, there are going to be findings of avoidable. There are going to be findings of inconsistency. Interesting part will come with the justifications. And I would expect the United States to go in the first place to Article 20G. And only then, or in subsidiary order, to Article 20A, public morals, public 20B, or 20G. Or 20D, excuse me, 20D. We won't say much about it now because I'll reserve my analysis of Article 20 when we talk about CBAM. I have to decide where I was going to do it, and we've got some more things to say about CBAM. So I'm just giving you the bare bones. Yeah? If you want to invoke Article 20G, the first question that you would have to ask, that's about measures that relate to the conservation of exhaustible natural resources. That's where how it starts. Well, what is the exhaustible natural resource here? The climate, a stable climate. That's what the answer has to be. But then you have the relate to requirement. The relate to requirement is a very soft requirement compared with the necessity requirement that you have under the other paragraphs of Article 20. You only have to have a real and close relationship between the measure and the conservation of exhaustible natural resources, and the measure may not be disproportionate to the end of conserving exhaustible natural resources. So that's not very difficult. And then the measure has to make effective. The other big condition to invoke Article 20G. The measure has to be made effective in conjunction with domestic restrictions. Again, not going to pause on this. We'll say more when we talk about CBAM. The other possible justification is Article 20A, B, and D. Why does one go first to G? Well, because if you go for A, B, and D, you'll be confronted with a necessity requirement. And again, I'll say more about that when we talk about CBAM. Don't forget that even if you have a measure that is provisionally justified under either 20G or under 20A, B, and D, you still have to meet the conditions of the chapeau. The application of the measure may not constitute arbitrary or unjustifiable discrimination or a restriction on international trade. I think, it's just a guess because we don't know, but I think that the United States will also try to invoke Article 21. And if they do so, the first question that will arise, or the first argument that the United States will make, is that the invocation of Article 21 is not justiciable. So that when a country states that, yes, this is a measure that is inconsistent with the GATT obligation, inconsistent with Article 1.1, Most Favored Nation treatment obligation, or inconsistent with Article 3.4, the national treatment obligation. When they invoke Article 21, national security, and they say, then the panel cannot assess this. Because Article 21, the invocation of Article 21 is not justiciable. Well, the panel first of all, for many, many, many years, actually until the case I'm going to refer to in a moment, which had a ruling in 2019, for many years, GATT contracting parties before the establishment of the WTO and WTO members did not bring Article 21 cases to dispute settlement. The national security exception was, of course, invoked, but it was never brought into dispute settlement. So the first time that a panel ruled on what actually Article 21 means was in the Russia traffic and transit case between Russia and Ukraine. Russia being the respondent, Ukraine the complainant. And the main argument of Russia in that case was that the panel did not have jurisdiction. This case was not justiciable. And it argued that because if you read Article 21, it does indeed say that members have the right to take measures that they consider necessary to protect national security interests. The actual text does not they consider, but they say it considers, that a member considers, it considers necessary. And on that basis, Russia and the United States, in that case, as a very, very prominent and active third party, argued, well, on that basis, we have to say that this is not justiciable. It's in the complete discretion of a WTO member to invoke Article 21, national security. The panel decided that this was not the case. Yeah? The panel decided that the invocation of Article 21 was justiciable. This line should read the invocation, justification under Article 21. I'll change that still. Now, what does the panel then do? Yeah? I'm not going to go into the reasoning why the panel thought it was justiciable. Take it from me, these cases are justiciable. But what does a panel then do? What does a panel have to see? It have to, what does a panel have to examine? It has to examine whether the measure, and in this case, we're talking about this tax credit, whether the tax credit was taken in a time of war or other emergency in international relations. Now, it was definitely not taken in time of war, but arguably, at least that's what the United States may want to argue, once they've lost the point of justiciability, which they will lose because they've already themselves in cases lost it now a few times, that panels have said, no, there is jurisdiction for panels when Article 21 is invoked. They are going to argue that this is a measure taken in time of other emergency in international relations. And that raises the question whether the climate crisis is indeed an emergency in international relations. Well, under the current, and I have some American scholars, friends, that are already building an argument in that way. Say, the way in which we should interpret, so sort of also evolutionary interpretation, in which we should interpret an emergency in international relations that includes the crisis, the climate crisis. The panel, it's a panel report that was never appealed, it was adopted by the DSB. The panel report in Russian traffic and transit has defined what an emergency in international relations is. And they've defined it as a situation of armed conflict, or of threatened armed conflict, or of heightened tension or crisis, or of general instability engulfing or surrounding a state. And this is a quote. Now, I'll let you decide whether the climate crisis fits within that definition. I think most of us would say no. It's a very serious crisis, but it's not an emergency in international relations. There may be a very adventurous panel that is going to take that. But looking at the panelists that have currently been appointed, I don't think that is so adventurous. So probably they will lose on this point. There are two more things that the panel can look at, but there the it considers really kicks in. Because the it considers clearly refers to what a national security interest is. And at the bottom of the page, I will say it clearly relates also to whether the measure is necessary. And since it is which a member considers to be a national security interest, there's wide discretion, very wide discretion for the member that invokes the national security, the national security exception to define what an essential security interest is. But there is still a limitation. This was one of the brilliant things that the panel in Russia Traffic in Transit did. They said there is a limitation because there is a general obligation under international law, an obligation that is reflected in the Vienna Convention on the Law of Treaties, but it's really a customary international law obligation that you have to interpret and apply obligations in treaties that you have agreed to in good faith. So you have to, a WTO member, the United States in this context, has to, when it determines what an essential security interest is, it has to give meaning to that concept in good faith. And the panel in Russia Traffic in Transit has already said, well, the very least that needs to happen is that the member invoking the national security exception has to articulate what that essential security interest is. It has to make it. Why is that necessary? Well, it has to be articulated sufficiently to demonstrate its veracity. So what you won't get away with is just to claim, oh, well, it's something very vague, and perhaps fighting the climate crisis would be too vague. Something very vague, and then say, well, that's our national security interest. No, it has to be articulated sufficiently. And by the way, in the Russian traffic in transit case, Russia got away with a very minimally defined national security interests. But the panel explicitly made a comment that what they see here done by Russia is the very minimum. And the other thing is the necessity of the measure, which it considers necessary. There again, wide discretion. But again, there's an obligation to interpret and apply Article 21 in good faith. And that means that you cannot argue that the measure is necessary when that measure is implausible as a measure to protect the essential security interest invoked. Or to put it as I have it here on the slide, the measure may not be implausible as a measure to protect the national security interest. Now, we'll see what the United States does here, but I would not be surprised if they try to argue that this is a measure necessary for national security, the protection of national security. And this brings us to CBAM. I'll give you a break. But I'm starting with CBAM because there's a lot to be said. And at 12 o'clock, I have to hand over to Professor Sharma, who's going to tell you much more interesting things about CBAM, because CBAM related to India. But let me start. Yes, of course.
Decide on something that has not been completed. So, for instance, when they say that the minerals have to be extracted from the North American territory, mining in itself is considered as the most ecologically devastating activity. So they're claiming that we are, enacting IRA for environmental protection, but they're also saying that mining would be undertaken under this IRA for people to get subsidies. And then plan this way.
Continue developing that thought, but they don't say that it's enacted for environmental objectives. They say that it is enacted to reduce greenhouse gas emissions.
But it itself would then result in greenhouse gas emissions because mining is not.
My understanding, the problem with mining, strict mining, is not so much the greenhouse gas emissions, but the ecological destruction of forests and loss of biodiversity and you name it.
No? They're also saying processing of mineral. They're not just saying extraction of mineral processing.
The processing, but the processing is more a question of pollution of water. Yeah. Again, not greenhouse gas, but by all means, I think you're onto it to something. If you want to apply the chapeau of Article 20, and you may want to come back with your comment when we talk about CBAM. All right, CBAM. Here, we're actually looking in a case, that's not the case. We're looking at a measure that has not yet been challenged in the WTO. And I would like to address with you the following questions. First of all, what is CBAM about? Yeah? And why was it adopted? In other words, what were the objectives? Or what are the objectives? Then, the question that inspires us all, is CBAM WTO consistent? Is CBAM likely to be challenged? And if so, by whom? And then finally, I'll ask you to make a choice. Because the United States and the European Union have, when you just look at the measures that we are discussing in this course, have a very different approach to addressing the climate crisis. The United States has chosen for subsidization. The European Union chooses for carbon pricing. Question is carbon pricing the better unilateral instrument, or a better unilateral way of addressing the climate crisis, or would subsidization be a better one? And this, of course, also has a developing country dimension, because imposing a carbon price is a more realistic option for many developing countries than subsidization. That's where we will finish. Now, CBAM. I need to start by talking not about CBAM itself, but I need to start talking about domestic carbon pricing. What is domestic carbon pricing? Well, that is to put a price on carbon. And you can put a price on carbon, as a matter of fact, in two ways. You can impose a carbon tax, or you can work with emission allowances. Now, the carbon price can either be set administratively, and that can be the case both when you work with a carbon tax, and then it's always set administratively, but also when you work with emission allowances. When you work with emission allowances, you can also administratively set the price of these allowances. But a carbon price, when you work with emission allowances, can also be set through the market of allowances. Often there's a sort of combination, and there's an initial price set on allowances in an administrative way. And then there is the possibility of trading it. And then, of course, the market will then determine the carbon price. Thank you very much. Now, carbon pricing has been recognized as indispensable and effective in reducing carbon emissions. The indispensable is a sort of statement that is meant to trigger reaction. And perhaps also the effective may be challenged. But in 70 jurisdictions, they currently have carbon pricing. Of course, the jurisdiction that is best known in this context is the European Union. European Union that quite some years ago established its emission trading system. That emission trading system explains why we now have CBAM. And it explains why we have now CBAM because of carbon leakage. So I have to explain now what carbon leakage is. And we have already discussed this before, so I can go fast. What is carbon leakage? Well, what you see is that the production of carbon-intensive products moves to countries with lower climate ambitions, moves to countries with no or lower carbon pricing. And this is, of course, bad, because you lose employment. Factories just move to a country with lower or no carbon pricing. But it doesn't stop there. Carbon leakage has yet another dimension. And that dimension is that you get importation of the cheaper carbon-intensive products from the countries with no or lower carbon pricing. And obviously, this leads to combination of the two, leads to two factors separately also lead to loss of employment, loss of competitiveness. And this is important in understanding part of the motivation behind CBAM. No net reduction of global carbon emissions, because the carbon emissions are just relocated. Still happen. They're not happening anymore in these countries that have high carbon prices or carbon prices. They move to somewhere else. Now, how do you respond to carbon leakage? Because if a government is confronted with loss of employment, loss of competitiveness, and doesn't see that something is done about the global problem of greenhouse gas emissions, which affects the climate and therefore affects also them. So what do you do to carbon leakage? You can take domestic measures. And this is what the European Union has been doing for many years. You take domestic measures in the form of tax exemptions and or free emission allowances. Free emission allowances that the European Union has been using. Tax exemptions and free emission allowances for domestic, carbon-intensive and trade-exposed industries. The European steel industry, for example, which is very polluting in the sense that they have high carbon emissions. They got in order to remain competitive, in order for the companies not to move abroad, they got emission allowances. Yes, there were limits on how much carbon industries were allowed to emit, but the steel industry, among other industries, they got emission allowances, so they were allowed to pollute in order to stay competitive, in order not to see the companies move abroad. What these domestic measures do, domestic measures to address carbon leakage, is that they level down the carbon prices for domestic producers. So they push down the carbon prices for domestic producers through the allowances, push down for domestic producers. But they leave domestic carbon emissions partly unaddressed. Think of my example of the steel industry. The steel industry will continue to emit high levels of carbon. And this, for the environmentalists within Europe, was unacceptable. And this was the prime motivator, at least initially, to see. Because apart from taking domestic measures, you can also take, in order to address carbon leakage, you can take trade measures. And trade measures take the form of a carbon tax that is imposed on imported carbon-intensive products. And what you do then is you level up the carbon prices of foreign producers. And this is, of course, what environmentalists want us to see. You address carbon emissions in other countries. How is that? Well, because these other countries and the producers in these other countries probably want to avoid the carbon tax. And the only way to avoid the carbon tax is to themselves imposing carbon taxes on the production domestically. From that sort of shift from addressing carbon leakage through domestic measures to address carbon leakage through trade measures, out of that, the CBAM was born. And CBAM is, if you want to define it in a few words, CBAM is a carbon price equalization measure. It imposes the same carbon price on emissions embedded in imported products as is applied on emissions at home. Main features of CBAM are the following. First of all, we have to talk about the product scope of application. And at this moment, that product scope of application is still very much focused on products that are known to be very polluting, which the production is known to be very polluting in the sense of emitting carbon. So the scope of application is currently limited to imports of products in sectors with significant risk of carbon leakage. And which are these sectors? Probably aware of that. Aluminium, cement, iron and steel, fertilizer, electricity, and hydrogen. And as Professor Sharma informed me this morning, particular steel and aluminium are of importance here for India, because was it 14%? 14% of the steel exports go to the European Union. So, and once the carbon taxes kick in, which will be beginning of 2026, Indian steel will be subject to carbon tax, but you may qualify that statement, and we'll see. Right. We'll come to that. We'll come to that. We'll come to that. The one thing that I already hinted at is that this is an initial list. And whenever you read a document of the European Commission on CBAM, they are predicting that the list will become longer. Yeah? The scope will be expanded. And that may actually already happen pretty soon. And even more products will be affected. Timeline for application, and once we've done that, I'll give you a break. I'll come back to the question after the break. Timeline for application. Well, the CBAM system has kicked into operation in October 2023, but is currently in a transitional period that will last until the end of this year. A transitional period in which is where there are mainly reporting obligations. So importers of products that fall under the scope of application of CBAM have to report how much they import and how much carbon is embedded in these imported products. So they're gathering information in order to see. It is only as from January 2026 that carbon taxes will be imposed. And we will have, we'll have a transitional period between 2026 and 2034, in which we'll see a gradual phase-in of CBAM, and in parallel, a gradual phasing out of the allowances that are given to domestic producers, the emission allowances that are given to domestic producers. Okay, next thing on our agenda of main features will be the declaration, and that has to be made by the importer. But let's have a break now.